All right. Hello, everybody. I am noticing that we have quite a few people signed in through Zoom. I know there are some people who will not be able to make it today, but just to make sure everybody's in the right place, this is the meeting for our annual policies and procedures training. It's November 19th, 2020 at about 1 p.m., just a few seconds after 1 p.m. now. I've told people to expect this training to take about 1 hour, and so I want to dive right into it in just a minute here. First off, this is our first time doing this meeting by Zoom. I think all of us can agree, hopefully the last time as well, but for purposes of this training, I just want to go over a few things so that everybody knows what's going on and has the ability to participate if you want to do that. So first of all, the Zoom software, some of you might be connecting on a phone, some of you might be connecting on your desktop. They function a little bit differently. First off, just know I have everyone muted by default. That's just to keep things clean and ensure that everybody can hear me. If you do need to, if you want to ask a question, you want to jump in and add something to the training, you're certainly welcome to do that. You do that in Zoom by raising your hand, just sort of like in any training. So to do that, if you're on a desktop, look down toward the bottom of the screen. If you can't see the controls at the bottom of the Zoom window, wiggle your mouse a little bit, you'll see it there. There's a button that says participants. And if you click on participants, that will either show or hide the participant panel. And if you find your name on that side, there should be either a button right there that says raise your hand, or there's a button that says more. You click on the more button, and then you can raise your hand. And once I notice that you have your hand raised, I'll go ahead and unmute you to speak, give your question or your comment. And then after that's done, you'll go back on mute, and nobody will be able to hear you until you're unmuted again. So that's that. Also, there is a chat function that you'll also see on the controls at the bottom of your screen. That'll enable you to make a written comment or question in the chat box. I'll be keeping my eye on that throughout the meeting here. And if something comes up in chat, then I'll be able to respond to that. Lastly, if somebody for some reason has a problem with Zoom or has a question, you're not able to, for some reason, unmute your connection or to use the chat box, you can always just shoot me an email. I'm monitoring my email here. It's christiank@hildalecity.com. And so let's see, I'm trying to think if there's anything else we need to cover. Oh, yes. So as far as attendance, we are required to report attendance for this training to Roger Carter, our court monitor. And in order to do that, we need to have your signature on something saying that you attended. Some of you may be in the training room over at the Colvin Street Police Station. And for those of you that are there, I believe we have a paper sign-in sheet for you to sign and show that you're present. If you're not there, you're either watching on Zoom or you're watching in some other way, I need to make sure that you complete your affidavit of training and turn that in. That goes for those of you that watch this meeting in recorded format later on, and it is being recorded. We will save the recording and distribute that to anybody that needs to watch it later. So if your coworker says to you, hey, I did make it to the training on Thursday, do you know how I watched that? Just tell them, come, get a hold of Christian, get a hold of Vance, get a hold of your supervisor, and we can get them a copy of the training video. Now I'm going to go ahead and jump into the training here. I'm going to share my screen with you. So what you should be seeing right now is you should see the slideshow of the training, as well as my face on the side, hopefully, so we can keep a little bit of a connection. You may be seeing other people's faces or other people's icons on the side. Zoom does give you the ability to change that to just the active speaker. If you don't want to see everybody else, you can do that. So if you're not able to see the slide that says Hildale and Colorado City, new policies, procedures, regulations, and ordinances, if you can't see that slide right now, please let me know in the chat box or raise your hand and we'll try to get that straightened out, okay? With that, I'm gonna go ahead and dive right into it. All right, so the reason that we're here is, as most of you should be aware, the towns of Colorado City and Hildale are subject to a court injunction by Judge Holland. It was put in place in the Federal District Court in April of 2017. It's a 10-year injunction, and if we are able to complete the Sorry, I'm getting a question right now, so hold on just a moment. Okay, there we go. Sorry about that. So the injunction was put in place in April 2017 and contains a bunch of different requirements regarding policing and housing that the cities are required to keep up with. One of those things is annual training. I'll go through that in more detail, but just suffice it to say for right now, annually we're required to give our employees and officials training on the policies and procedures that have been implemented to implement the federal court injunction. And that's what we're here to talk about today. All right, so we're going to be talking about the requirements in the injunction and how we've implemented that. There are two parts of the injunction, and if you haven't read it yet, the entire injunction, I recommend you do that. It's available online. It's also available in our office. I'm happy to provide you with a copy. You could also get a copy from the clerk for either town, and I highly recommend you read through it. The injunction's divided up into two parts. So the first part is, well, I should clarify the operative provisions of the injunction. The first part is the Policing Act injunction. The second part is the Fair Housing Act injunction. So what the Policing Act does is it was passed by Congress some number of years ago, and it protects people from patterns or practices by law enforcement officers that violate their constitutional rights. So what constitutional rights are we talking about? And to be clear, the judge has, besides what the law tells us we have to do, the judge has put it in an injunction that we have to follow the law, and the penalties to doing that can be greater than if we had never been found guilty of discrimination in the first place, because rather than everybody else who's just subject to the law in general, we are subject to the law and to the injunction. So the injunction also prohibits the cities from violating the Establishment Clause, violating the Fourth Amendment to the Constitution, we're talking US Constitution, of course, and violating the Equal Protection Clause of the 14th Amendment. I'm going to tell you a little bit about what those are. So the Establishment Clause is what guarantees us freedom of religion in the United States. And it says, number one, that there can't be any laws favoring or establishing a religion. So if we are making local regulations or enforcing local regulations in a way that promotes a specific religion, that violates the Establishment Clause. The First Amendment also protects the right to free exercise of religion, and we're also required to accommodate people's individual religious observances. So that's first of all, and this is all we're talking right now with respect to policing, and so that's that. With the Fourth Amendment, what the Fourth Amendment talks about, and this has a lot to do with policing, is unlawful search, unlawful seizure, unlawful arrest, There are specific requirements under the Fourth Amendment and all the case law interpreting that guides everything that the police do every day, and that was also part of the injunction. Also prohibited from violating the Equal Protection Clause. What does the Equal Protection Clause of the 14th Amendment say? It says that the government has to give every person equal protection of the law, regardless of who they are or what they believe. Moving on, the injunction also requires the marshal's office to have a police consultant. So we've had that police consultant, Jim Keith, in place for a couple of years now, and the consultant does a lot of things. A lot of those things have already happened. The job is more of an ongoing sort of maintenance role right now. But in the beginning of the injunction, there were a lot of things that the marshal's office had to do, and the police consultant was appointed to help with those things. So that was putting new policies and procedures in place. The department had to hire 2 additional officers right away after the injunction was put into place. They needed to do a comprehensive review and update of all the marshal's office policies, and Mr. Keith was involved in all of that. The department also had to acquire body cameras, get up to speed and to current police practices, and set up a training program for our officers in the marshal's office, as well as you see here, meeting with county law enforcement officials, and also the cities were required to obtain a mentor to help the chief marshal get all this done, and to identify the appropriate law enforcement practices. And that was Chief Flowers was with us for a couple of years, all the way up until about a year ago. So there's no longer a police chief mentor. There is still a police consultant. That's something that we are likely to be working with for the foreseeable future. The Fair Housing Act injunction deals with a mandatory requirement under the injunction that we not violate the Fair Housing Act. Again, going above and beyond the statute, if we violate these things, then we're in violation of a court order. What's the Fair Housing Act? It is a title of the Civil Rights Act of 1968 that was put in place to protect housing opportunities as a basic right. Everybody has a right to housing, and there are provisions in the law that make it illegal to deny housing opportunities based on 7 characteristics, including religion, which was what was at stake in the DOJ case. So according to the act and according to the injunction, the cities cannot make housing unavailable or deny housing opportunities. So that includes refusing utility service, making it prohibitively and arbitrarily expensive to build new housing in town, and then also to discriminate in terms, conditions, or privileges of rental or sale of a dwelling because of religion, or frankly, under the law, any other protected characteristic. Discriminating, again, in utility services, police services, any municipal services that touch on housing are not allowed to have any discrimination. And then lastly, and this is the interference part, so you have these rights not to be discriminated against as a resident, and not to be denied housing opportunities. And if you assert those rights, you have the right to not have that assertion of your rights interfered with. So that means the cities can't coerce, intimidate, threaten, or interfere with anybody who has asserted those rights. So if someone has come into the office and has said, I think you're not hooking up my utilities because of my religion, or whatever the case may be, and someone in the office decides, I don't like that, I'm not going to talk to that person, or I'm going to or I'm going to slip their utility application into the round file, right? And it's never seen again. Those would all be those interferences with that right, and we're not allowed to do that. Also, Colorado City was told in the injunction by the judge to work with the UEP to approve and record a subdivision plat. This has happened now. So if you're not aware, Colorado City, much of the property there was not subdivided up until I think last year, when finally a subdivision plat was approved. Might have been 2 years ago. I could be wrong on my timing there, but so the Colorado City did approve the subdivision plat. The UEP did record that, and now that unsubdivided property in Colorado City has now become subdivided, and that was something that was required by the injunction. That's why that happened. Moving on to building department, there were violations found in the city's building department practices. We do share a building department. We share a building department staff, and for the most part, we follow the same policies with little differences in state law. But this was found to be, there were found to be violations in the way that we applied our building department policies and procedures. So there were changes put in place. The injunction required us to adopt objective, uniform, non-discriminatory policies and procedures for the building department. And that includes the whole process, all the way from applying for a building permit to the building official doing plan review, inspectors doing building inspections, and then once all that's done, are we denying building permit applications? Are we revoking them? Are we considering them expired? And how are we assessing fees throughout that whole process? The injunction required our policies and procedures in the building department to include statements about non-discrimination, that we can't take action on a permit for arbitrary or religiously based reasons. And then also, because of the complicated property issues here in this town, there was a requirement that, first of all, the policies say that a building permit will not be issued unless there is a signature of the property owner on the building permit application. And then the injunction also said our application form needed to be changed to have lines for the name and signature of the property owner or the property owner's representative. So that's the version of that form that you should be using if you have anything to do with taking or processing building permit applications. We're also required to give 14 days written notice to the owner and the applicant before expiration or cancellation of a permit. And that information also has to be passed along to the court monitor, so be aware of that. And then lastly, we're required to have an appeal procedure in place. The procedures that have now already been adopted, these were adopted a few years ago, they can only be modified with written notice to the Department of Justice and to our court monitor, and they have to be given 30 days in order to consider those modifications before we can put them into effect. We have to justify with documentation our reasons for needing to make changes to those policies. And you'll see that as a common thread, whether we're talking about building department policies, marshal's office, or utility department policies and procedures. They're all going to require notice to both the DOJ and to the court monitor before we can do that. It's really important not to miss that step, because while under state law, those kinds of changes may still be valid and enforceable, the fact that we've done it, if we don't give that required notice, can be contempt of court and can be a violation of the court order. It's really important not to make any changes to those policies and realize that we cannot make any changes to those policies without going through a process mandated in the injunction. Also, the policies cannot be enforced in a way that discriminates based on religion. In other words, just because the DOJ has signed off on a particular building department policy or any other policy under the injunction does not mean that if a particular individual comes in front of the city looking for a building permit or looking for some sort of a permit, that we can read into the policy something we're literally allowed to do, but we're doing it differently because of the person that's in front of us. The policies need to be enforced the same for every person that's in front of the city. That's the entire point of having policies, and if we don't do that, then we're going to run into problems. Now, the injunction also required us to make changes to our water service regulations. If you're not familiar, that both towns do have water service regulations that govern how the utility department deals with and provides service to its customers. Now, back before the Cook case several years ago, the cities had regulations in place that said that if someone wanted to connect into the system, they had to bring new water with them. They had to bring water rights. They had to bring the source capacity to provide service at their connection. And the judge in the injunction said, first of all, we'd already made some changes and put in place impact fees and some things to eliminate those requirements, but there were still some remaining parts in the regulations that were still appeared to keep those regulations in place. And so the judge said we were going to have to amend our regulations in order to take that out. Also, similarly to the building permit requirements, we were going to, we have to allow a utility customer that's applying for a transfer of service from one prior resident to them to be able to do that only by signing a statement subject to penalty of perjury that says they have permission to either occupy the premises or just to obtain utilities for the premises. But that's all they have to do is sign that statement and then provide proof. So they have to provide some kind of documentation. And we're required to change our regulations to reflect that. The injunction made clear that the regulations are not to require anyone to have to get permission from a pre-existing customer on a particular property. It cannot require people to provide proof that they have extinguished all potential rights to the property and anybody else before they can get utility service or any kind of waiting period. And so so we've made those changes. I'll talk about that in a minute. But again, like I said, common thread, there has to be notice to the government and notice to the court monitor at least 30 days before any kind of modifications to water service regulations can go in effect. This means we have some great idea that could maybe make service better, make things better for the customers and the residents. All the same, we still have to go through that process to get that, to give the opportunity to comment or to object to the government and to the court monitor. And again, not enforce those regulations and in any kind of a discriminatory manner. It shouldn't matter who's in front of you. It should matter what the regulations say. Sorry, I want to make sure I didn't jump past anything. Now, impact fees. Again, both cities put impact fees in place a few years ago, in part to deal with the issue of new customers coming into town and these new water regulations. We came more in line with state law that says that you're supposed to pay for those kinds of increases in demand through impact fees. So the cities had put impact fees in place, and then the DOJ had asserted in the course of the case that the impact fees were not based in reality for a variety of reasons. The judge, in looking at it, said there's potentially a problem with the growth in source capacity that was being projected through the study that had been done with an engineering firm that the city had worked with before. And so what the injunction said was we have to go out and get another engineering firm to take a look at it, give us another updated impact fee report. And then if that showed that the impact fee was too high, that the cities would have to revise it down. And so we did go through that. Alpha Engineering was brought in. They did that updated impact fee study, and the cities actually did end up making a change. It was a very small change, but we did make a change to the water impact fee in order to reflect that, and that brought us into compliance with the injunction. Now, again, we can't just move that impact fee right back up now and say, okay, well, we complied with the injunction, now we can just jump it up to anything we want, let alone anything in state law. The injunction says that in order for the impact fee, the water impact fee, to be changed at all, that first we have to give that 30-day notice to the government and to the court monitor in order for them to have an opportunity to look at what we're trying to do, look at the documentation of why we're trying to do it, and give their input or their objection if they have any. The injunction also says that we have to go through that process of reevaluating impact fees no less than 5-year intervals. That's the same for Colorado City under Arizona state law. Hildale also follows Colorado City because of this 5-year interval requirement. The injunction also requires us to keep our websites updated. So we have to have a website. Both cities, and we do. We have websites. There's public information on both of the websites, and there's very specific requirements about what the homepage of the website has to show. So that's as soon as you come onto the website, the very first page you see has to have this information. So there has to be contact information for our officials, for our department heads. There needs to be information on there about upcoming city council and utility board meetings. There's also a documents section for how people can apply for municipal services. So people should be and are required by the injunction to be able to go on our websites and get the forms, or get even an online form to apply for a building permit, a utility connection, a zoning change, whatever the case may be. That's all supposed to be online. So this is above and beyond what state law requires. A lot of these things are not, some of them are, but most of them are not required by state law to be on our websites. But for reasons of accessibility and other reasons, the judge felt that it was important to include that in the injunction. Also, that a lot of the information that we produce as municipalities be offered online, so people need to be able to get to on our websites our ordinances, our codes, our regulations, procedures, policies. The marshal's office manual is required to be there, and then any revisions that we make have to go up on the website. So if one of these things is changed, especially having to do with housing, especially having to do with utilities, they have to be very quickly updated to the websites. And there have been some instances where I think we've probably taken longer than we should have taken to get things up online. We need to make sure that we are doing our very best to ensure that all this information required by the injunction is not only on the websites, but kept up to date. There's also, if you've looked at either city's website, you'll see there's a statement about that the cities have been found guilty by the district court of discrimination. There's a whole statement. That language comes directly out of the injunction. The injunction is what requires us to have that statement on our website. We're also required to provide certain education and training. The marshal's office has its own specific training requirements. We're also, under the Fair Housing Act injunction, required to give all employees that could possibly affect housing, whether it be through utilities or policing or zoning or any of those types of employees, to be trained on, first, the requirements of the injunction and policies, procedures, regulations. That's what we're here talking about today. We're also required to have a constitutional training on the requirements of the First, Fourth, and 14th Amendments, and a separate training on the Fair Housing Act. Those were initially in the injunction. If you read it, they were required to be all lumped together and all given at the same time. What you wouldn't be able to tell by looking at the injunction is there were actually a series of orders that came after that, where the judge recognized some of the logistical problems with providing the training the way the injunction stated. And so we're still required to give those trainings. We're still required to do it annually and when people are hired on. but we have a little more flexibility in being able to break it up into separate trainings and do them at a little bit different times of year so that so we can keep rolling through these and keep in compliance on them. I want to reiterate, new hires have to be given the videos of these trainings within 30 days. And it is a few hours at a time when we're getting somebody on board, getting them trained and up to speed. But all the same, it's absolutely essential to make sure that they get that training and that they get their affidavits in showing that they did that training. That's what this last part on this slide is about. There has to be a signed verification that that employees or officials that are required to get the training, they have to sign it and say, I got this training. And just doing it once isn't enough. It has to be done within the 30 days of hire, or within 30 days of election or appointment, and then every single year after that. So it's not a one and done kind of thing. It has to be updated regularly. Now we're going to talk about the court monitor. Actually, you know what? This is probably a good place. Forgive me, I am learning a bit here. I do want to make sure if anybody has any questions. I haven't seen any hands raised yet. I don't think I've seen anything in the chat yet, but I'm just going to take a pause here for a minute. This is a lot of information to digest. Are there any questions burning in anyone's mind? Is there anything, any concern that you've had come up that you want to make sure that we talk about? Thank you, Stacy. I'm also, while I'm waiting for anybody else that might feel they need to ask a question, I want to look through our list of participants here and make sure that we know everybody that's on here. So let's see. All right, looks good. I'm not seeing any more comments or questions on here. I don't see any hands raised, so I'm going to go ahead and get back to our presentation here. All right. I think I accidentally moved us around a little bit. There we go. So again, the court monitor part of the housing injunction was meant to solve the problem that the judge wants to make sure that we stay compliant with the requirements of the injunction. But the judge doesn't have the boots on the ground kind of perspective to be in our council meetings, be in our planning commission meetings, to be able to see what's going on and keep the cities honest. Really, frankly, it's in everyone's best interest that if there's a problem, it get noticed and that it get brought up and resolved as quickly as possible with the lowest amount of conflict and, frankly, the lowest amount of involvement from the judge. The judge doesn't need to be hearing from our friends over at the Department of Justice that we're having problems with Hildale and Colorado City. So the monitor is that boots on the ground to keep an eye on us. Roger Carter has been very, very good, very helpful, and keeps us honest. He's very, very familiar and well-versed in the terms of the injunction. And he and I often have conversations about those. They not really any terrible problems have come up yet, but just things where the injunction tells us how things are to be done, and generally we are on the same page because we're both very familiar with what the injunction requires, and it does, believe me, go in a lot more depth than what we're able to go over today. So the monitor's there to help us. The monitor's there especially to help the court and make sure that the injunction is appropriately implemented, that we're following the Fair Housing Act. And so to do that, he has a number of different things that he's required by the injunction to do. So everything you see here is straight out of the injunction. The monitor has to have the ability and has to use the ability to do site visits, to interview people, to review documents. That doesn't mean that he is going through every single application that the city gets. It just means he's doing a systematic review of things that are going on, applications that are coming in, how things are being processed to make sure that things aren't falling through the cracks, that things aren't happening that shouldn't be happening. So again, reviewing applications, reviewing requests, that have to do with utilities, building department, and licenses, certificates, subdivision and zoning issues, variances. And sometimes people ask for relief from especially land use rules. And when that happens, we let Roger know so that he can keep an eye on how things are progressing. Those sorts of requests do actually, it can and do generate complaints. And there have been some of those things that we have had to work our way through. The monitor is also required by the injunction to look at anything we're trying to change. So if we're making changes to ordinances, regulations, resolutions, right, procedures, policies, anything that affects housing or municipal services related to housing, so that's your utilities, your police services, and so on, we have to give him the opportunity to take a look at that and raise any issues that there might be. Also, Roger's our point of contact for the public or other stakeholders to make complaints when they believe that our actions have maybe affected rights when it comes to housing. And Roger does take those and he goes through them. He will sit down with people. He will sit down with people from the city and make sure that he fully understands before he reaches any conclusions. We have been fortunate to have not had any major issues come up with the complaints that have come in, but they do give us an opportunity to make sure that we are cutting as close to our requirements under the law as we possibly can. And Roger only helps with that, and we're really grateful for what he does. He's also there to look at any changes to the policies and procedures that we already talked about. So those building department policies, water service regulations, the water impact fees, and I know he may also take interest in changes to the marshal's office policies to the effect that might affect the city's obligations under the FHA. And then he lastly has the job of reporting to the courts and to the parties every 6 months now. It was every quarter for the first couple of years, and now we're down to every 6 months. We get a report from Roger that says how we're doing on complying with the injunction. It's really a good way for us to get a read on, are we missing something? Is there a problem? If there gets to be a big enough problem where we're non-compliant and and we don't jump quick to correct that problem, then we might run into a situation where Roger has to report that not only to our officials here, but also to officials at the Justice Department, and in some cases may have to actually take something bring something to the court's attention. So again, he's that eyes and ears, boots on the ground for the court to keep us honest and keep us in compliance and bring up any issues that do come up. Now, from the city's from the city side of things, we have an obligation under the injunction to cooperate in every possible way with the court monitor. So that means our meetings, our deliberations of our public bodies are an open book. Our documents, our files are an open book to the monitor in general. So when we're having meetings, the monitor needs to get notice of those meetings, and it needs to be timely. It needs to be as far enough in advance to allow him to attend. Even if we're having an emergency meeting, the monitor should probably be the first person called right after the last council member in order to put him on notice that, hey, there's an emergency meeting happening. He also needs to know, just like the public, what the topics considered in those meetings is going to be. So we need to make sure, not only because state noticing requirements, but because of the injunction, that we are properly noticing our meetings and including all of the topics that are going to be subject to discussion, and especially topics that are going to be subject to possible action. Again, we have to allow the monitor full access to meetings. We don't get to kick the monitor out at any time. There may be some very unlikely circumstance where in a closed meeting that the city might find it necessary to ask the monitor not to be there. But even in that case, he'll probably have the right to see recordings or whatever kind of information that he needs to get in order to appropriately monitor the cities. In general, even executive sessions, even closed meetings of our public bodies have to be open to the monitor. And there are provisions in the injunction that make clear that the monitor has an obligation to keep those things secret, just like anybody else in the room. But he's, in general, can't be blocked from attending those executive sessions. And if he's not able to make it to one, we have to keep the recordings so that he can view those later and stay abreast of what went on. Also, and this is an important thing, the monitor has the ability to contact anyone in the city. We can maybe have a point of contact, but we can't say, oh, you're not going to talk to that person. You can only talk to me. You can only talk to so-and-so. Every person in the city has to be available to the monitor if it's relevant to his job under the injunction, as well as documents, data, trainings. I see Roger's logged on for this training here. So he needs to be fully apprised of everything that's going on here at the cities to the greatest extent possible. Again, the reports were initially required to be every 90 days. Now we're down to one report every 6 months. We just got another report, very, very good. It reminded us of our training obligations, but other than that, we're found compliant with the injunction, and that seems to have been the pattern over the last few years. If, however, the monitor does, after investigating a complaint or investigating something that's come to his attention, the monitor discovers that there is a problem with a violation, then he has to give us a written report, and he has to give that also to the government, and then offer us an opportunity to respond, and offer an opportunity to provide documentation, witnesses, anything that might help to explain the situation. But even though we have the opportunity to respond, I want to emphasize we need to make sure that we're as familiar with our obligations under the law and under the injunctions we can possibly be, and that we are in open communication with each other, with management here, and with the court monitor to ensure that we're maintaining compliance and we're not getting to that point ever of having to have a written report that there's possible violations of the law. That's not a situation that we want to get into. Records not only have to be made available to the monitor, but the judge has said in the injunction, records have to be preserved for the entire period of the injunction. And actually, I think it's possible to even read the injunction to mean we'll need to preserve those records even for some time after the injunction is over. We have to be able to document our compliance or non-compliance, for that matter, with the injunction. That means even if, let's say, the recordings of this training or the sign-in sheet from this training today might not be required by state law to be kept more than a few years, all the same, the injunction requires that we keep these records on file for at least those 10 years of the injunction. So be aware of that. The last thing we want to do is to be put in a position where we need to be able to document our compliance with the injunction, and we can't find anything because it ended up getting shredded with everything else. We need to be very careful to maintain records of any kind that might have to do with our compliance with the injunction. Now, the court's jurisdiction for the 10 years that the injunction is in force, it is allowed under the law. It's something that we're going to be living with unless we can, for some reason, convince the judge at some point that we've done so very well that the injunction should be terminated early. It's with us for 10 years. And the judge has jurisdiction under the law to enforce the terms of the injunction. This is a constitutional power of the courts to be able to enforce federal law on instruments of the state, like the cities. And so this is something to take very seriously. A violation of the injunction can be contempt of court or worse. And also, if the government believes that that we're not in compliance, not getting and staying in compliance with the law and with the injunction, they can actually ask the judge to go further than 10 years. So besides the fact that we all want to make sure that we're in compliance with the law, we wanted to make sure that we establish the absolute best record of performance under this injunction so that we can avoid that kind of a situation. Nobody wants to see Hildale or Colorado City in that sort of a situation. There are a number of time limits under the injunction on when things have to happen. A lot of those have already happened when it came to a lot of the initial changes that we talked about as far as changes to the policies and procedures, ordinances, and so on. But there are other time limits that we still are under, including time limits for training, time limits for notice to the government or notice to the court monitor. And unless we can agree or get permission from the court to change those deadlines, then we have to follow them. Not following them can actually lead us into non-compliance with the injunction and problems that I've already talked about. Again, we already talked about things that we have made changes to: the water service regulations, building department policies and procedures, culinary water impact fee. Also, I mentioned under the Policing Act injunction, there were changes made to the Marshal's office, hiring officers, conducting training, making changes to the policy manual there. And as part of that, there were resolutions and ordinances that had to be adopted to make them happen. So the first one of those is an ordinance in Hildale City, and I believe it was a resolution in Colorado City. But what they both did, and I'll go over them both, is they dealt with that new water issue. So the language in the statute, or rather the ordinance, that the court had found was problematic was struck out by this Hildale City ordinance. So we struck out the language that said that no new service location will be connected unless the individual is able to adequately bring water to the system. That's not how we do things anymore, and we have struck that out of the Hildale City Code. There were a few other changes there, but the big thing was eliminating the new water requirement. Same thing with resolution number 2017-14 in Colorado City. It made those changes to the new water connection requirements that required, and you see here under B something very similar to what Hildale's had. Colorado City had provisions that said applicants have to bring new water in order to be connected to the system, and these changes eliminated that. There was also a resolution in Colorado City and a resolution in Hildale City, both adopting amended water service regulations. The big thing that changed was this requirement that we allow customers to transfer service simply by providing a statement under perjury that they have the authority to ask for a utility connection or occupy the premises, and show proof either that they own the premises or they have permission to get utility services there. And there are specific terms spelled out in our water service regulations to enable that to happen. It also took out provisions in the water service regulations for verifying change in occupancy. So it has now changed to say that upon request by a new customer, the department will cancel the current customer's service agreement. And that terms outlined in section 30.10 has to do with with providing that sworn statement and that documentation that they have authority to get utility service at that location. There were also provisions that allowed the cities to obtain liens against customers' property in the event of non-payment. Those provisions have now been deleted. And now some of you have already seen this. This is a copy of the updated utility services application that we use. And the main changes that you'll see are on page 2 and page 3 of the application. So first off, you'll see down toward about 2/3 of the way down the page on the left there, you'll see it says Hildale, Colorado City Utility Departments are committed to serving all customers without discrimination. Utility services shall not be denied on the basis of religion, race, color, national origin, or ethnicity, gender, or any other basis protected under the Fair Housing Act. So yes, this statement is true. We are committed. We're also under court injunction and under legal mandate, but we are committed to meet those obligations and provide services without discrimination. Page 3 was a new page, and it dealt with that issue of transferring a utility connection. And I think we have a close-up here. So it added this language from the water service regulations saying what somebody has to do to transfer service. And that was, instead of the old requirements that maybe required them to jump through a few more hoops, all that we are requiring them to do is to sign the application under penalty of perjury to say that they either own the property or they have the right to get utility services there, and then show proof of that. And here's what that signature block looks like. And here is the part of the form that the utility department fills out on every application to note, was that proof provided? What was it? And then fill out the name and date of when that utility department employee filled that out. So we have documentation, or ideally have documentation in every customer file that that's taken place. Again, the city's also adopted changes to the building department policies and procedures. And I'm going to go over some of the key provisions in those policies and procedures. So first off, applies to both Hildale and Colorado City. There is a provision in there in the policy that says that it is to be enforced uniformly, without discrimination, no action taken for arbitrary reasons or on the basis of religion. And I'll emphasize here, under the law, it's not just discrimination on religion, it's also discrimination on several other bases as well, including race, sex, familial status. There's 7 in all, and if you need more information on what those classes are, then we can get those to you. But the key thing to remember is you should be treating every single person as an individual, not based on any group characteristic. And the better that we can all do at adopting that attitude, the better we can avoid running into any kind of problems in the future. 102 has to do with the application itself. So the policy requires us to have applications for building permits available in the office and on the website. The applicant has to get that application and file it, and there's specific information that is required to be on there under 102.02. 103 has to do with how plan reviews get done. There's state code, I believe, in both Utah and Arizona on how plan reviews are supposed to get done, when they're supposed to get done. Our local policies and procedures also have specific requirements as far as that goes, what the building official has to do, looking at the application, checking it against the codes, and notifying applicants if there's any kind of a deficiency. We can't just sit on plan reviews, and I think our building department does a great job at this, but we can't just sit on plan reviews and never let the applicant know that there's a problem. That can always turn into an issue with discrimination, because there's bound to be something that that person is going to claim was different about them, is a protected class under the law, and now it looks like we're violating the Fair Housing Act. We don't ever want to get in that situation, so it's best for us to keep these applications moving along. This isn't just Andy that has to think about that, our building official. It's the people that take the applications, the people that take the payments, the planning and zoning employees that have to do planning reviews on building permit applications. We all have to make sure that we're keeping things moving on these. So the building permit is under section 104, has to be issued after everything's been reviewed, everything's been turned in. We have to get that signature of the property owner or their representative. And the policy also makes clear, again, like the injunction requires, that owners get a 14-day notice before anything is revised. Sorry, bear with me just a second here. All right, so sorry, that broke my train of thought there. Anyhow, before any permit can be revoked or canceled or considered expired, there has to be 14-day notice, and there has to be an opportunity for an appeal, for the applicant to appeal any adverse decision. And those appeals processes are in our code. There is a deadline for someone to file an appeal, and it runs from the date of the notice of the final adverse decision. So once an applicant gets notice from the city, we are denying your application or we're canceling your building permit, so on and so forth. That starts the clock on when they have to, what they have to do and when they have to do it. And you can see those code sections to, if you have any more questions about that. What is an adverse decision? It's any decision that's significantly adverse to a permit holder. So the examples of that could be denying a permit, withdrawing it, voiding, canceling a permit, but it could be other things such as rejecting a permit application from planning and zoning review or anything like that. If it's a significantly adverse decision on a building permit application, then they have a right to appeal. Inspections under 105, there are requirements for the applicant to request the inspections, to leave the work exposed, and also that the inspections have to be done in a timely manner. And again, there are provisions in state code about that. Here's an image of the building permit application. You can see there, similar to the utilities application, we added a signature block for the applicant and a signature block for the owner. And let's see. Oh, this is just showing the Hildale City application, essentially the same. Now getting into impact fees, what you're looking at here is a letter that Hildale and Colorado City got from Alpha Engineering about the culinary water impact fee facilities plan and impact fee analysis review. So under the court order, Alpha Engineering did go through, they did take consideration of the bifurcation of residential connections versus non-residential connections, which the judge was worried may have artificially inflated demand and so artificially inflated the impact fee. And you can see here the findings that they presented to us was, first of all, they looked at the capital facilities plan and found it would be appropriate to reduce the fee by $180 per connection. What they did find, though, is that splitting out those commercial industrial from residential didn't actually significantly affect the usage projections. What did make a difference was the water rights. There were water rights the city had acquired, and it was different from the cost projections in the original impact fee analysis. So they did redo the math and found out that there was a difference in $180. So Colorado City adopted a resolution, as did Hildale City, changing those water meter impact fees to reflect the $180 change. That is all I had on my slides, but I want to know if anyone has any comments, any questions. If you raise your hand, again, you just click that under the participants button on the control ribbon, would be at the bottom of the screen there. If you're on mobile, it's there's a little 3 dots, more details menu on the bottom right-hand side of your mobile screen. Either way, you can raise your hand and ask a question. All right, so I'm calling on Harrison here.
I just wanted to say I appreciate all the work that you did, Christian. Obviously, it definitely a lot of work that went into this. I want to say that I appreciate all your hard work, and Look forward to everyone's questions. Please feel free to let us know. We definitely want to make sure that we are on the right side here. So
I appreciate that, Harrison. I really like doing this. It's, you know, part of the reason why I'm here at Hildale City in the first place. And so I really appreciate the opportunity to talk to everybody. Is there anybody else? Let's see. Harrison, is your hand up or did you have something else to say?
nope, just that. Sorry about that.
Okay. There you go. I lowered your hand for you. Anybody else? I'm also watching the chat box here. I don't see any questions. See, thank yous. Thank you guys too. Let's hang on here for just another couple of minutes. I'm sorry, I know that it's at 2 o'clock. I'm happy to stay on for as much longer as anybody else has things that they'd like to talk about. But if there aren't any other questions or comments or anything anybody wants to bring up, then that is our hour. That's the end of the training. There are, like I say, a lot more details in the injunction. I encourage you to read it. I think everybody should. They're all, some of it can be a little tough to understand, but you read it over and over again, it should start to make sense. And I'm also happy to talk to anybody that has any questions. So as far as attendance, I just want to let everybody know, thank you for being here. We do have a list. This meeting is being recorded. Your attendance is recorded, and I will make sure that we get an affidavit out to everybody here that you can sign and get turned back in to show that you completed your training obligation, and that'll go over to our court monitor. Somebody had asked a question, is it possible to sign in online? Your name, again, it is recorded, and so we do have a record of you being on the meeting. If there's any issue at all, if somebody gets with you and says, hey, you've got to complete your training, if you sign an affidavit saying you did the training today, that will be accepted as proof that you did that. All right. Well, like I said, I'm going to hang on here for a few more minutes in case anybody has questions come up. But if you need to go, please feel free to do so. And I just really appreciate you logging on here. For those of you that are on the phone,